yesterday and talked to you about development agreements. And we'll talk a little bit more about some of the concepts you just heard Bart talk about, and I will take a few more minutes to cover them. I know the first time down the furrow, it's hard and there's lots of clods and they're big. And you go down the furrow a few more times and they break up and get a little smaller and it's a little easier. I know the first time I heard the word adjudicative, what in the heck is adjudicate or adjudicative mean? Now I just use it and I understand it, but that's taken me years. And so I hope I don't say something that causes you to wonder, what in the heck are you talking about? But if I do, please raise your hand. There's no bad question. So why do lawsuits happen? Well, I think one big reason is people get mad. They don't feel like they were treated fairly. Even if it turns out you were right, they get mad. I'll tell you a little story about Rex Lee. Rex Lee was the dean of the BYU Law School and then president of BYU. He was also the U.S. Solicitor General, I believe, under the Reagan administration. He taught constitutional law when I went to BYU, and he said something I've always remembered. People will always be mad if they can't say what they want. There's nothing worse than an undelivered speech, he would say. And when people come to a public hearing and they want to say something, by golly, you better listen to them. That's good advice, and I've always listened to it. The other night at Salt Lake, you may have read in the paper, we were talking about the Sugar House streetcar line. We had more people than we could handle. They were in the chambers, they were in the hallway, they were in the overflow room. They were put into some of the offices around on that floor. We turned on the computer so people could watch the video link, and everybody got to say whatever they wanted. They were only given 2 minutes apiece, but we kept going until the line ended. Some people went home, but no one could say they didn't have a chance to say their piece. So people get angry when they don't get what they want. We make careless mistakes. Sometimes we're arbitrary about things. There are probably other reasons why people sue us. Maybe they have the money. I've heard about some cases over the years. The case down in Springville with the doctor there. Boy, he didn't give up for what, 10 years? It's a long time. Why do people sue us? What are the reasons that they will use? They may claim that we violated a substantive rule of law. Constitutional rule. You heard about takings from Bart a few minutes ago. We have problems in sign ordinances with free speech. Sometimes we regulate political signs, and we say people can't put up political signs or only a certain amount of time. That is going to be a problem. Don't regulate political signs. If you do, there's many ordinances out there that do. My recommendation is take it out of your zoning code, make it exempt. Failure to follow proper procedure is another big reason why we lose lawsuits. And it's the easiest reason to resolve. If you don't know the procedure that is associated with a particular application, you should know it, and if it's not clear, you should write it down and put it in your code book. And I want to mention this now before I forget, but I've written about 10 zoning codes over the years, and I'll refer you to one that I think turned out well, and that's Centerville. It's on the sterlingcodifiers.com webpage, or you can go to Centerville and I'm sure get a link to it. But in that code we have an administrative procedures chapter. Now there's various ways you can organize these. Some zoning codes will put the procedure in the section where the substantive rules are, but we decided to put all the procedures in one place in the code. And so you can see how the code is organized. I helped Mike McCandless there from Emory County do their code. Unfortunately, their code isn't on Sterling, but it's there and you can look at it. It's a little harder to find, but I did find it the other day. Same idea. It lays out in the code who can do what when. What pieces of paper do you have to submit as an applicant to have a complete application? We heard about that. Who gets to decide? What's the basis for the decision? what happens after the decision is done, who gets to appeal, what's the time for appeal, how long does the decision last. You heard the question in the last session about what's reasonable diligence. You can put into your code a rule that says a preliminary application for subdivision is good for 2 years. If you don't come in with a final application for subdivision within 2 years, your application has expired. Good, no more vested rights, they're done. But if you don't have that sort of a rule in your code book, then you're going to have to be arguing about whether or not the applicant had diligently pursued the application or not. It's going to be a big factual fight, and it's a lot easier just to specify a reasonable time in your code. Okay, by now I hope you all know what the police power is. I'll just let you take a quick look at this slide. It's the power by which regulations are enacted for the benefit of the public, to protect the public health. That's the basic source of authority by which we do zoning. I mentioned yesterday the Hutchinson case. It's important to remember if you're pioneering anything in zoning in particular. CLEDMA gives us a lot of authority, but under Hutchinson we have additional authority, and basically it says, this is a review, you can do anything that's in the public interest if you have a valid public purpose, and the courts are not going to interfere with what you're doing unless it's unconstitutional or it's against the state law or the federal law of some kind. So you get to do it unless there's a specific rule that says you can't. In the Utah Code, there's similar authority based on LUDMA. A county may provide a service, exercise a power, or perform a function that is reasonably related to the safety, health, morals, and welfare of county inhabitants, except as limited or prohibited by statute. That sounds a lot like the Hutchinson case. I think that's what it was based on. Same thing in CLEDMA. Now this is a long, dense paragraph. I'm not going to read it to you, because here it is again, and I took it apart and outlined it. So it's a little easier to understand. But under CLEDMA, you can enact all ordinances, resolutions, and rules, may enter into other forms of land use controls and development agreements, as we mentioned yesterday, considered necessary or appropriate for the use and development of land within unincorporated areas. It includes ordinances, resolutions, rules, restrictive covenants, easements, developments, agreements governing, and this is the list in the code, uses, density, open spaces, structures, buildings, energy efficiency, light and air quality, transportation and public or alternative transportation, infrastructure, street and building orientation and width requirements, public facilities. You must do it in a way that's fundamentally fair, and with considerations of surrounding land uses and balancing the foregoing purposes with a landowner's private property interest and height and location of vegetation and trees and landscaping. I don't think this is as well written as it could be, but that's what it says. Is there anything that's not in there? Yes, there's some things that aren't in there. You can do a lot, but there's some things you may not do under the zoning ordinance, so recognize where your limits are. Zoning ordinances can be very broad, but basically they regulate the use of land and the development of structures on the land and things related to that. There are state laws and federal laws that affect what you do. Any federal law which is contrary to what you do, or state law, is going to preempt or override what you're doing. So you need to be aware of it. Here's just, I have in the handouts 2 lists of statutory things from federal and from Utah laws that affect you. And it's a long list, and it's not a comprehensive list. This is just an oh, by the way, for example list. You should be familiar with these, at least have a nodding familiarity with them, that they exist, so that if something comes up that you're doing in your zoning ordinance that's affected by one of these statutes, and have somebody take a look at it, or have your lawyers look at it, or maybe you'll want to learn more about it yourself. Very important to be aware of these things. Sometimes I've noticed that what localities do is they act like they have authority to approve things that they really don't, and they put in the basis of the approval a requirement that compliance occur with that other law. For instance, you would say, this subdivision is approved as long as you get the clean water permits that you need from the federal government. Well, why are you saying that? You're putting yourself in between the federal government and the clean water permit holder, and you're interposing yourself as in a way that I think will create conflict and gives you responsibilities implicitly. Perhaps you really don't have any because it's not your law, it's a federal law, but you've imposed it as a condition of approval. Just be aware that it's there, but the applicant's going to have to meet that requirement. I recommend that you put as a condition only the things that you have control over in your own ordinances, not what somebody else is doing. Because if the federal government thinks that a clean water permit's not issuable, or yes it is, that will happen. You want to ask for evidence that it's been issued before you issue the permit, then put that into your code book and say, we're not going to issue an approval for a subdivision unless you show up at the counter with an approval from the federal government, and then we'll consider it. If you think it's that important, then put it in your code book. Oh, a big one is billboards. You all know about the billboard wars. If your code doesn't already have something in the sign ordinance, if you have a sign ordinance, I recommend you put something in there that says, billboards aren't regulated under this ordinance. They're regulated by state law. And just refer to that if you have a billboard, because the state law is changing all the time. And inevitably, your code's going to get out of date. And as Bart said, LUDMA and CLEDMA are constantly changing. And so another provision perhaps put in your code is something to the effect that these are our rules, but if there is a newer rule that supersedes it, the newer rule will apply. Just sort of a general catch-all, so that if there's a conflict, we know where the answer is, whether it's in the state law or your ordinance. Under the broad authority granted by the statute and by the case law, there's really very little you can do in terms of zoning. A new wrinkle, a new fad in zoning is so-called form-based zoning. I don't know if any of you are trying to do that. Instead of having a list of uses, the code really controls how buildings look and where they're located, and with secondary or even tertiary interest in uses. The theory being that if it looks right and nobody knows what's going on inside the building and you can't hear it, smell it, or feel it, why do we care what's happening inside the building? It's a different approach. Okay. So, as a general rule, what is it that we can do under the police power? We can protect public health and safety. We need to say why we're doing stuff when we invoke that rule. As you heard on the takings claims, we can't deprive an owner of all economic use. They have to have reasonable use. I may make a comment on that. People often say that reasonable use means that development must be approved. In their mind, reasonable use is a gas station on the corner out by the freeway. Now it's a field, and we're running some cattle on it, or maybe little alfalfa or something. And they demand a rezoning. And they say, well, if you don't rezone this, I'm going to sue you for a taking. I would say don't worry about that. You're probably going to be okay. If you get that kind of objection, you can say, well, fine, get in line with all the other people suing us, and you'll have your turn when we get there. A rezoning, as I said yesterday, is a legislative act with a high level of discretion. And as long as you're not taking away something from the property owner that they've always had the right to do, I don't think you're going to have a takings problem. The regulations need to be reasonably clear and definite. One of the problems we have a lot is that we make up things as we go. If we don't say something in our ordinance, we tend to fill the gap with a policy that we made up. And that's going to trip us up if we're doing that. If you encounter a problem more than once, you probably should write it down and put it in your code book and say, this is how we deal with this problem. Remember the 1-3 bite rule from yesterday? You get one time to have the problem, after that you gotta fix it. Okay. Here are the common problem areas I'm going to discuss, just briefly. Distinguishing between legislative and administrative. Bart went over that. I'm going to give you a little more detail. Procedural violations, vested rights, exactions, impact fees, conditional use permits, group homes, and ambiguous ordinance provisions. That's a big one. We have a lot of problems with that. Planners write things that are hard to enforce. I'm a planner. I'm as guilty as the rest. I try to avoid it, however. So the land use process is divided into two great halves, policy and implementation. Keep that in mind. What are the policy things that we do? We have an annexation plan. We have a general plan or a master plan. Maybe we have subsidiary plans. Salt Lake has, I think there must be 25 different master plans, which together comprise the entire city plan. So they have a little neighborhood master plan for 5-acre area. They'll have one for the southwest quadrant of town. Some people just have one plan for the whole town, for the whole county. But all of those together are a policy for the development of the community. You have a capital improvement program. How are we going to spend our money? Where are we going to spend it? And why are we going to spend it? Policy, a policy document. Usually a 5-year or 10-year capital improvement plan, which you do as part of your budget. Of course, the budget is a policy document at the end of the day. Where are we going to spend our money? On the other hand, we have implementing rules. The zoning code is one of several rules that we use to implement policy. Subdivision regulations, building and health codes, and the capital improvement act. Construction is how we implement the budget. So, what's the difference between legislative and administrative? This is how you can think of it. Legislative is fundamentally a political process about choices, about values. Why do we do this versus why do we do that? It's how we feel. It's fundamentally political. It's fundamentally political, and that's why the judges, the courts, are not going to interfere in a political process. As long as you have followed the right procedure, you can make whatever political decisions in zoning that you want to make. You want to zone it X, Y, or Z. The judge is not going to complain about that unless you violated the Constitution, violated a statute that applies to the situation, or you violated a procedure that applies to the situation. But absent that, you basically get to choose what you want to do and how you want to do it. Administrative, by contrast, is taking a generally applicable rule, a law or an ordinance, and applying it to individual circumstances. The guy who shows up at the counter for a conditional use permit or a building permit or a subdivision approval is asking you to take the rules that apply to subdivisions, for instance, and apply them to him and his property and decide whether he gets to do a subdivision and how. Quasi-judicial, different category, often lumped with the administrative. And the two great halves, legislative on one half, administrative on the other half, and a subpart of the administrative is quasi-judicial, sometimes referred to as ministerial as well. Quasi-judicial is basically dealing with appeals. When someone complains that we haven't followed the ordinance correctly, and they have the right of an appeal to the Board of Adjustment typically, or some other appellate body, quasi-judicial rules apply. It's an administrative process. We must be very sure we follow the right procedure. If we make a procedural goof, it can be fatal to the outcome. You won't get what you want. Very little discretion associated with administrative and quasi-judicial. Great discretion associated with legislative. Okay. I have a handout. I'd like you to look at it. It's in your packet. It's called Differences Between Types of Proceedings. And I've got 3 columns there. It's too big to put on a slide and you wouldn't be able to read it, so I'll just have you read it along with me. So if you look on the left-hand column, we've got the factors. And then we have legislative, administrative, quasi-judicial, and then another column called ministerial. So you can draw a line down between the legislative and administrative, and you've had the two great halves. Okay? So, on the first one, who's affected? Under legislative, it's everybody. On the administrative, it's an individual who's affected. What about the level of discretion allowed? Legislative, it's very high. Under administrative, there's some. Under ministerial, virtually none. Ministerial, let me give you an example. Someone wants a building permit to put up a garage in the backyard of their single-family lot. The zoning code says garages are permitted. They have to be so far from the property line. They can't be higher than a certain number of feet, etc. There's no discretion there. If a person shows up with his application, if he meets the standards, you will issue the permit. Nothing said. End of story. That's a ministerial action. No discretion. Just a question of checking off the code requirements. Ex parte contacts. Ex parte contacts are contacts with an applicant outside the hearing room. Ex parte contacts are just fine in a legislative context. So, because, why? It's the political context. So when we're making up an ordinance, when we're having a hearing about an ordinance, Farmer Smith sees Commissioner Jones in the grocery store and says, hey, I heard about that rezoning. I want to tell you how I feel about it. Is that okay? That's fine. No problem. It's a legislative thing. Can he show up at the hearing and say the same thing or write a letter? Sure he could. Now let's say that Farmer Jones meets the commissioner in the grocery store on a conditional use permit. And he says, I want to tell you about that conditional use permit and why I don't think you should approve it. The answer should be, I'm sorry, I can't hear you right now. That would be an improper ex parte contact. Come to the hearing and testify or write a letter that we can put into the record telling us what your opinion is. We'd be glad to hear it. But because of due process and fairness considerations, I can't talk to you right now. Improper ex parte contact happens all the time. And it can deep six you if it gets out of control. It should never happen, theoretically. But if it's, yes, sir.
That's, you're referring to the decision maker can't have that ex parte contact.
The decision maker.
So the zoning administrator is the decision maker. What about the political participants getting involved in trying to influence that?
What about give me the last question again, what about the what?
If it's a zoning administrator having to make a decision, he or she is the decision maker, but you've got some political pressure from higher sources to decide one way or another. Where is the ex parte contact not permitted? So zoning administrator is reviewing my barn. I go to my political representative and say he's being mean to me. Is that an ex parte?
It's not technically an ex parte contact, but you should resist it, obviously, because you have a duty as the administrator to approve it fairly according to whatever the code says. End of story. And you have to, unfortunately, I say unfortunately, or I'm not sure what the right adjective is, but you have the difficult task of explaining to the elected official, I don't have any discretion. If you want to change the code, you may change the standards so that the next time we'll use a new set of standards. But for this one, they've made an application, it's complete, they're entitled to the approval under the standards in place when they made their application, and I can't do anything different.
Okay, but it's not ex parte.
It's not ex parte. Ex parte refers to something in a hearing or not in a hearing.
Okay. Thanks.
Okay. You heard from Bart, but I'll review this again. What's the basis for the decision? If it's legislative, anything that could advance the public welfare is sufficient to justify the decision. It could advance. Substantial evidence is required in an administrative case, and as he explained, substantial evidence isn't really very much. It's more than a scintilla, a little bit, and less than a preponderance. Preponderance means more likely than not that something is true. So if you want to put it in percentage terms, it's like from 1% to 49% of the total evidence available. That may be helpful to think about it that way. It's not very much. What do you do when you have in a conditional use hearing and people are testifying X and they're testifying Y? Let's say about traffic. One person says the traffic's going to be horrible, and you have an engineer saying it's going to create a problem. And you have an engineer on the other side said, no, the traffic's not a problem whatsoever. It comes down to an issue of credibility. Who do you believe? It's just like a jury determining the credibility of a witness in a trial. One juror is going to believe this person more than that person. And that's what you do as a decision maker. You just find out who's more credible. And it's an amount of evidence necessary to convince a reasonable mind of a particular conclusion. That's substantial evidence. What's the standard of review on appeal? In a legislative case, if the issue is reasonably debatable, if this decision versus that decision can be fairly debated as to one or the other is proper, the court's going to say, hey, we're not getting into that fight. We're going to just leave it as is. It was a political decision. It was a legislative decision. You used the right procedure. You didn't violate any of the statutory rules or constitutional rules that might apply to this. You're good to go. On the other hand, on the administrative side, if you don't have substantial evidence in the record to justify your decision, then that can be a potential problem. Okay, I've gone over this slide just a minute ago when we looked at this handout, so I won't take any more time on this one. If you don't have sufficient standards in your ordinance, and you make a decision, one potential claim that will be made against you is that you delegated legislative authority to an administrative person who doesn't have the power to exercise that authority. If you have no standards in your code and you're making them up, even though they might be really good, that's going to be a problem for you. Public clamor. Let's make a comment about public clamor. What is public clamor? It's not defined in the case law, but here's Neil's definition. Public clamor is a point of view or an opinion with no apparent basis in fact. It may have a basis in fact, but it's not apparent when the statement is made. Is public clamor okay in a legislative hearing on a rezoning? Absolutely. No problem. People can say stupid things all they want. And if the commissioners want to be influenced by that, good. That's their decision. They're political people, and they make decisions for who knows what reasons why. I've learned over the years that the stated reasons why we decide something may be the real reason, but oftentimes it's not. Something else is going on that I may or may not find about it in the future. Okay, that's fine. Whatever the basis is, it is in a legislative case. On the administrative side, public clamor is never permitted. And I'm talking about in a hearing setting. So if you have somebody in a conditional use permit hearing standing up and saying, I hate that use, it's stupid, it's going to cause me problems having all these cars go by, is that a sufficient basis to say no? No, it's not. How about if the person stood up and said, I've been counting the cars in front of my house, and from 7 o'clock in the morning to 7 o'clock at night I counted 150 cars going by for a whole week. Is that public clamor? No, that's evidence. I mean, if the person is credible, you can decide to believe it. And you say, well, how did you determine that? Well, I just kind of stood out there and kind of watched. Well, maybe then you don't see it didn't have any credibility. But what if he says, I had my chart out there, and I counted them one after the other, and I put down a little tick mark on my paper every time a car went by for 24 hours. Oh, that's probably pretty good evidence of that particular issue. So you have to judge what's the basis of the evidence. If we follow the procedure, we're fine. If we don't, it's illegal. Now, here's the phrasing of what I'm talking about in the law is called arbitrary, capricious, or illegal. And you see that phrasing in the case law over and over. Well, if it's arbitrary, capricious, or illegal, we'll overturn it. But if it's not, we'll sustain it. Well, what does that mean? Arbitrary, or capricious, or illegal. The courts have broken it down. In the Bradley case, particularly, that Bart referred to. Arbitrary and capricious essentially means reasonable. In a legislative case, reasonable means it could advance the public welfare. In an administrative case, reasonable means substantial evidence is on the record. If it's arbitrary or capricious, it's not reasonable. That's what it means. Arbitrary and capricious is sort of the other side of the reasonable coin. Illegal means what it implies. You follow the wrong procedure. It's against some law. It's a constitutional rule or a statutory rule. Maybe it's against your own law and your own zoning ordinance. If you enact a barrier in your own zoning ordinance or a rule, you're expected to follow it. If you don't, it would be illegal. Okay, I mentioned this at the outset, but I'm going to re-emphasize it. Take a look at that Centerville Code or the Emory County Code. Put down in writing is my strong appeal to you. All of these things in your code book. What constitutes an application? You know, what are we applying for? I want you to take a look now and get your materials again and look at this sample land use and appeals authorities chart. You have more decision makers perhaps in your code than you realize. This is from a Utah community. I prepared this as part of the work that I was doing for them. And we went through the code and we identified all the people and all the bodies that were making decisions. And we were saying, well, who makes this decision and on what basis do they make it? And once it's been decided, what do they get to do? What's the applicant get to do next? So we kind of consolidated it all in this chart. And it would be helpful to go through this exercise in your own code and say, who are our decision makers? The appeal authorities and the land use authorities. And associated then with each of those, we took in the Centerville Code and the Emory County Code, and we said all the things that apply with regard to each one of these criteria. Who, what, when, how long does the appeal last, working to appeal to, etc. We organize this chart with the legislative things first, the administrative things next, and then we put the quasi-judicial things at the bottom. And you can see who's deciding. It's very helpful. There's a rule also in Lebanon that says the same people that make the first decision can't be on the appeal process. Well, that makes sense. Not fair. But you'd be surprised how often that happens if you've got commissioners or county commissioners or planning commissioners involved as decision makers. Sometimes inadvertently you put them in the position of hearing something on an appeal. That's the problem. The code specifically prohibits it. Okay, now we're going to talk about making findings for a minute. And you've got another handout in your materials on findings. It's called Making Required Findings. You can kind of look at that as we go along here. What is a finding? It's not a simple declaration of, I find X. It's more than that. You have to show all your work. You have to show why you got to the end result, to the end conclusion that you have drawn. A finding is a citation of specific facts in the application in front of you that you find to be true that lead to a conclusion that the application either conforms or does not conform to your code standard. Now, information is not the same as facts. You have to sort it all out. When you have a public hearing on a conditional use permit, for instance, again, I'm talking primarily now in an administrative context. Findings primarily apply to an administrative context. Reasons would apply to a legislative context. But remember, there might not be a good reason for a legislative, for a rezoning, and the court would still uphold it. So I'm talking now in an administrative context about findings. You have to weigh the evidence. What happens many times in our hearings, I've noticed, is we don't sort out the information from the facts that are relevant to the decision. We have a set of minutes that are approved. At the end of the minutes, it says, Commissioner Jones moved that the conditional use permit be approved. Well, on what basis was it approved? Commissioner Jones moved that the conditional use be approved because it meets the code requirements. Is that enough? It's not going to be enough. You need to take the next step and say, it's approved because this section of the code, these standards were met as shown by X evidence. Now, if you're fortunate enough to have a staff Hopefully your staff is doing that in their staff memo, and it's laid out. And so you could say, I move that this be approved subject to the analysis in the staff memorandum, which we accept and adopt as our own analysis. Or if you disagree, if you can articulate it right then and there, say, well, we deny it for these reasons. But if you're not sure you have it all put together yet, continue the hearing, or close the hearing, and continue the matter until your next meeting, and say, staff, we think that evidence is here sufficient to deny this application. This is generally what is be in the context of its denial, rather than approval. We'd like you as staff to work up the findings based on the testimony of this hearing and bring it back to us for a vote. Okay? And you can, especially on a controversial thing, take the time to do the work before you vote. If it's not controversial, then you can probably rule from the bench and not have a problem. You can weigh whether it's worth doing. But certainly if you have a controversial thing, don't be pressured. Don't be pressured into making a decision that very night if you're not prepared. Develop your record. That's essential, because your record is what goes up on appeal. It's not what you said, it's the record. And then the court has the job of sifting through the record to try to figure out what you did and why you did it. And sometimes courts will do that job for you, and they'll say, well, they didn't say exactly, but we see that this is probably what happened, and we accept it as the reasoning why they did what they did, and we're going to support them. But it's so much easier if you lay it all out for the judge on appeal. Because remember, you have two things on appeal, and administratively you have de novo, or you have on the record. That's an administrative appeal. So if you have the building permit person is making a decision and it goes up on appeal to the planning commission, if it were on the record, it would be whatever was in the file as developed by the building official, and the planning commission would say, oh, you did it right or you did it wrong based on what we see here in the file. That's an on-the-record review. If it's de novo, it's basically a do-over. You ignore the prior decision and you start again. So you have de novo or on the record within the administrative process in the county. But once it gets to court, it's going to be an on-the-record review. Whatever you did, you did. There's language in the statute in CLUDMA that says if sufficient evidence wasn't taken, the court may take additional evidence. But I rarely see that happen. Mostly they're just going to look at your record. I just can't tell you how important the record is. It starts on day one with the application, making sure that it's complete. People get careless about their applications. There's a fellow who used to come into Provo all the time. We knew him very well because he was a development consultant, represented a lot of guys. Mr. Smith signed at the bottom and the staff would fill in the application. That was bad practice. We should have made him fill it out, because it might go up on appeal and that application could become something very important in terms of evidence. Let me go back to the minutes problem that I was alluding to. You have the minutes of the meeting, which is all well and good, but you should also then have a separate section, either in your minutes or maybe a separate document, that says, this is our approval form. It was an application by John Jones. He was asking for a conditional use permit at this location. Here's what he was asking for. Here's our decision. Approved, subject to the following conditions. And at the bottom of it, you put a little thing that says, this approval is good for 2 years. You must take out a building permit, whatever it says in your code, or this permit will expire. No due diligence. No diligence by the applicant. Put all that in your form. Planning Commission chair signs it, or whoever the authority is approving it, signs it. That is the official record then of your decision. Lays out everything in a tidy little package. If you don't do that, I advocate that you do consider it. It's worth doing. You know, the one or two that you may go up on appeal to the courts, this will really, really be of great value to you. Take a quick look at this tips for creating an administrative record. You can look at it at your leisure. It covers many of the things that I have just mentioned, this other one, procedures that will get you into trouble. This is prepared by Sidney Fonsbeck. He's retired now. But this is great. This is all based on reality, you know. No need for formality. Let the audience speak from their seats and react to comments as if they're being made by applauding or booing. Bad move. In my opinion, a public hearing should be like a court proceeding. Everybody should be very respectful, and they should listen quietly. When you let hearings get out of hand, it creates all kinds of problems. And especially in a case where you have a constitutional issue that may be involved, let's take or a group home issue, for example, where you've got a state statute or a federal statute on it. This is just an example. Let's say in a group home setting, you're letting people boo and cheer and what have you. And then you make a decision that's being alleged was improper. And it turns out there might have been improper, or could have been. Well, you know what can happen is the people who are suing you can say that the expressions of opinion in the audience are being attributed to you, the decision maker, because you didn't do anything different. You didn't tone them down. The argument would be, you're adopting their position. That's the reason you decided what you decided, is because you were influenced by all that booing, clapping, and cheering. You don't want to be in that position. You just want to listen carefully to what people say, give everybody 2 minutes, 3 minutes, whatever time it is, and everybody should be respectful. No clapping, whatever. Sometimes you have to have a hard hand on the gavel. That's important. But it's also important from a due process point of view, because if you have someone there with a minority view, are they going to want to stand up and express their opinion? No, they're going to be intimidated. They're going to be intimidated. Maybe a strong-willed person might stand up and say something. It should be very respectful. Okay. Does anybody have any questions about vested rights? We've kind of gone over this a couple of times. No questions? I'll just make an additional comment about this compelling public interest will be jeopardized as a rule, as a way to vitiate a vested right. It's hard. It's hard to use this exception to the vested rights rule. But let me give you an example that might work, just to put it in perspective. Again, let's say a fellow comes in and he gets approval for a subdivision. He goes all the way through the process. He gets it platted. He comes in for building permits. You give him the permit, and he takes the backhoe, and he's starting to dig holes. And lo and behold, he runs into some old caskets. Whoa, it's the Pioneer Burial Ground. We thought it was over there, but we found, wow, thanks for finding that for us. Yeah. We're not going to let you subdivide anymore. Put that back. We're going to do a little more investigation, and this needs to be preserved as a Pioneer Burial Ground. Is that a compelling countervailing interest to vitiate a subdivision? Probably. Probably. I mean, contrast that with this that I've seen happen. There's a problem in the code. Someone brings something to you and says, gosh, this is a problem. We don't really want to approve it. But there's nothing in our code that prohibits it. I wonder if we can figure out something that would help us deny this. Oh, let's put in a new rule, and let's do a temporary zoning regulation. You know what a temporary zoning regulation is? It's allowed by flood law, and it lets you resolve immediately a problem that you hadn't yet experienced by imposing, without a hearing, a new rule. That's very, very often misused and abused. If you had the ability to foresee the problem and put a rule into place, but you didn't, I think the court is going to say, too bad, that rule is not going to help you. If you really do encounter something that's a problem you hadn't previously considered or even known about, and it's showing up sort of for the first time, then you can use a temporary zoning regulation, which is kind of part of the vested rights rules system, and you can put a new rule into place in a hurry and basically abrogate someone's rights. But it's hard to do, and just be aware, it's not a cure-all. It's there for complex situations that you may not have known about in advance. Okay, here's a review of the one dog bite rule. Okay, you all know this rule by heart now, right? Every dog gets one free bite. We have to anticipate problems in advance of their occurrence and draft ordinances to deal with them. That's the simple answer. I'm talking again in an administrative case. It's practically impossible to deny an administrative application, if it's in compliance with the rules. If it's in compliance with what you say is required. That's another important thing that needs to be in your code book. What is the stuff that they have to submit? For instance, it says you have to submit a transportation study. They don't submit a transportation study. Guess what? Application isn't complete. So maybe then you can deny it because their application was not complete. Therefore, they have no vested right. So take a look at the list of things that need to be there. If they're not there, then you have a duty to tell them your application is incomplete. I'm writing you a letter, and you're deficient in these two things. And as soon as you get those two things to us, we'll process the application. And oh, by the way, if you don't get those two things to us in the next month, we consider your application dead. You'll have to start over. You know, tell them how long they've got. Otherwise, it will be potentially a live application for who knows how long. Put a drop dead date on it. Okay. Exactions. We've talked about this a little bit. Bart talked about this a little bit. The BAM case was an exaction case. I mentioned it yesterday in the development agreements. Does anybody have any further questions on exactions? Because I'm going to cover some other things if you don't. Okay. Administrative exactions are the problem. We're asking for things as a condition of approval when there's no basis in the code for what we're asking. That's the problem. So put it in your code and say, you know, all sewer lines will be 12 inches, or put it on a map, you know, specify what your sewer sizes are and where they are. And you can say, well, you got to do a 12-inch sewer. Yes, Mike.
In ours, one of the things we do is has to deal with our road encroachment. We've actually talked about it in my presentation. So we require them, for instance, for something occurring on public land where they access with a county road to get a road encroachment permit. That road encroachment permit has its own set of rules and regulations. That's where those rules and regulations reside, not in our process.
Okay.
Does that create any problems because it's not clear in our process what those requirements might be?
No. My only recommendation would be to slip something in the code that says our rules for this thing is over there.
And that's what we do. We just require that that's a required component of the application.
It's always helpful to have cross-references, I believe, in the code book. It just helps people figure out what's going on. It's hard to follow anyway. Codes are pretty dense for those that are not familiar with them. Legislatively imposed exactions, that's a much more open situation, as I described yesterday. If you want to impose something as a condition of a rezoning, and the applicant says, okay, I accept, if he says, no, I don't accept, and you don't rezone, fine, you're done. Okay. There's a new rule about exactions I haven't heard anybody mention. It just came out in the statutes that were approved in the last session. And it came out of this BAM case. And it says if an exaction is required by another government entity, that is, if you as County X are doing something on the behalf of, say, UDOT, then that exaction has to be transferred to them. And I'm not quite sure how that's going to work, to be candid. And I think this was put in the statute. Am I being recorded?
Yes.
It was put in the statute as a political thing based on the developer's complaints about BAM. They didn't like the answer in BAM. I think the BAM decision, the final one, was a good decision. It upholds the government's position that we've argued. And this statute is a way of undermining BAM, but it doesn't make sense to me. And the implicit premise of this statute is that what we're talking about is property. But there are other kinds of exactions that are non-property, requiring someone to build something a certain way, or extend the sewer. But in the BAM case, we were talking about land for a right-of-way, and that's the basis upon which it was written. And you have to read it with that in mind, I think, because otherwise it doesn't make any sense. But it still doesn't make sense to me, so in BAM, there were 14 feet of right-of-way, which was an issue. So we're going to take 14 feet of right-of-way and transfer that to UDOT, and the rest of it's going to stay with the county. It's crazy. It doesn't make sense. And I think there's probably ways around it. I won't describe those here. I'll talk about those later.
Yeah.
Face-to-face with someone. Yes, another question.
Yeah, question about the bottom bullet there. So property that was extracted or exacted, needs to go back to the prior owner or to the adjacent owner. So if it's a
No,
right
so
of way.
if you acquire property as an exaction and then you don't use it, you must offer it back to the same owner or the successor owner of that property. If it's sold within 15 years, you've got to give it back to the people who gave it to you. Okay, just a word about impact fees. Another problem area which you can survive in court if you do it properly. I will simply say that impact fees have a great deal of procedural requirements. Not all impact fee consultants are the same. Some really have a good handle on what's going on, and others, well, not as good. So be careful who you hire to do your impact fee studies. If you do it right, you should have no problems in a lawsuit. There's a couple of cases brought by the Builders Association, American Fork and Logan a few years ago. They upheld the impact fee determinations of the government. If you've got a question, those are two good cases. The statute has changed since those cases were decided. There's been an attempt to simplify it. I hope it's simplified. That was what the objective was. But it's very, very specific in how this is to be done. We'll probably see more impact fee litigation because the developers hate impact fees. But really, impact fees is the answer to ad hoc exactions. And it spreads the burden on the whole community in an even way. Those who create new demand pay for it, and those who don't. So, that's all I will mention about impact fees. Okay, conditional use permits, not a discretionary device. Conditional use permits are an administrative device. The presumption is if you meet the requirements in the code, you will be approved, unless there's no set of conditions that will ameliorate the harm associated with that conditional use permit. So you can impose conditions to deal with the problem created by the conditional use permit at that specific location. And that's how you solve the problem. You'll impose particular conditions. That's why conditional uses are there. And so that you can, it's a flexible device. You can't come up with, apparently in theory, you can't come up with a set of rules that would apply in all cases everywhere throughout the community. You need some discretion. So you devise relatively flexible or general rules. The more general the rule, the harder it is to make findings because you have to marshal more factual evidence to show compliance with the general rule. If you have a very specific rule, it's easier in the findings context. For example, let me describe that. If you say, there shall be, let's say you're doing a gravel pit, and you say, there can't be any dust. Can't be any dust associated with trucks on the roads for a gravel pit. If there's no dust, we'll approve it. So you approve the gravel pit, and you say it's approved subject to the condition that there be no dust on the roads when the trucks go by. So then you get to an enforcement case. There's dust. People complain. You pull out your condition. There's no dust on the road when the trucks go by. Wow. That means no dust. Not one particle of dust, if read literally. Wow, that's probably, that's going to, how are we going to prove that? That's going to be very difficult. It would be better to say, I don't know if there's a way to measure dust, I'm just making this up as we go here. It would be better to say, there will not be more than a certain volume of dust within a certain distance of the road, between certain hours of the day. Can you see how I'm trying to get more specific about what the rule is? Be specific. Hours, location, time, amounts. This is particularly problematic for noise complaints. Use a noise meter to say the noise cannot be above a certain number of decibels between the hours of midnight and 6 a.m. Okay. So you take the meter out and you measure. Easily provable or not. But if you simply say it can't be too loud, no noise, that's very hard to prove.
What about deferring through condition of approval to the authority of a staff member, like the county engineer? So dust mitigation will be at the discretion of the county engineer. If the engineer calls out, we need to go out and clean it up.
Well, you can do that, but the county engineer has to be careful as well, because then, and you might say, delegate it to the county engineer in accordance with generally accepted engineering standards.
Okay.
Is there a generally accepted engineering standard for dust? Well, if there was one, it'd be better to say, in acceptance with a general engineering standard developed by AASHTO number XYZ. There it is, it's in black and white. It's an easier way to do it. I had a case recently in one of the counties on an energy situation where they had an injection well for trying to get rid of wastewater, and it smelled. And we had a big complaint about smell. Well, and all the county ordinance said was, there can't be any smells. How do you prove that? That there's a violation. I mean, even roses? So it was we tried to get them to put more specific things into their code. Okay, you've heard about group homes. I won't take any more time on group homes because we're almost out of time. Except to say, if you have a question about group homes, get someone who's an expert to help you. And then my last comments are about ambiguous ordinances, and I'll leave, I think, the rest of this for you to read. Legislative drafting is an art. And when you write something in your code, you need to write it in a way that takes into consideration the whole code. I can't tell you how many times I just see it paste on. You write one little section of something and it looks good for that, but then you read it in the context of the whole code, it doesn't make sense. It doesn't hang together. You need to know that your authority when you're writing your code. And of course, your primary goal is to give language to carry out the legislative intent. Of course, you're going to presume that you did it correctly, and they'll try to read it or interpret it in accordance with everything else you said. Every word in a code is used advisedly in the mind of the court. When you say cease and desist, it assumes you mean there's a difference between cease and desist. Why don't you just say stop? That'd be better. I think lawyers usually get paid by the word. Maybe they still do. I've never been able to do that. They overuse it's too much language. Use a simple word if a simple word will work. Don't use more than one word. If you have a particular term in your code, use the same term over and over. Don't say general plan, master plan, specific plan. If you have different terms for what is apparently the same thing, the court's going to say, well, those must be different because they're different words. We're going to assume that they are different. And then you say, well, what about the procedure that applies to a specific plan, master plan, or general plan? And you only have one procedure. Maybe you have two, and it's not clear which procedure applies. Use the same word to describe the same things. When there is a question about what your code says, guess what? The property owner gets the benefit of the doubt. That's very clear. It's going to be construed against the drafter, you. It assumes you knew what you were writing, and if there's ambiguity, it will be construed in favor of the property owner. Okay, some things to think about when you're writing. Uniformity versus flexibility, specificity versus discretion, consistency with existing regulations. Let me give you a couple quick examples in drafting, and then we'll be done. Here's an example. Assume a local housing assistance program assumes a definition for a qualifying low-income household. Is that the same thing as a federally defined low-income household? It'd be better to create a new term and say a county housing program recipient, specific to your program. Don't refer to the county program. Here's another example. Homeowners may not landscape yards with non-native trees. Okay, so what's got to be proved to enforce this rule? Well, first you've got to prove the person's a homeowner, not a tenant. You've got to prove that person planted a tree. The tree must be in the yard. So where's the yard? Is that the entire lot, or is that the front yard, the backyard, the side yard? I don't know, it just says yard. Tree must not be native to the area, and it can't be a bush. So when does a bush begin to be a tree? I don't know. You can have arguments about that. I mean, if you got into it, and this is kind of a silly little example, but you can see the way we use words, we can get into fights about what the words mean in a specific case. It'd be better to say, only trees shown on the county's native tree list may be planted in a residential lot. Is that more clear? I hope so. It's intended to be. It's much more specific. Okay. Use shall for required, may for permissive. I've got a couple of other examples here. Tabulation. You saw that example of the permission of the authority under the county code. It was one big, long, dense area. Very hard to follow. Use the outline style. You can see it in well-written codes. Much easier to understand, and much easier to understand how the parts of the sentence relate to the whole. Sometimes you wonder if something written at the end of the paragraph refers back to the first part, or the whole part, or just the last part. It gets confusing. Okay, I think we're done. We're out of time. I have a handout on due process, and you can look at that. It's got some stuff in there about bias that you should be aware of. Basically, bias isn't going to be a problem. Here's the things to think about, to just be aware of. Avoid conflicts, get proper notice, follow correct procedure, be fair, and know your standards of review. Thank you very much.